So, welcome everyone. Welcome to today's panel on the nature and purpose of comparative legal history. I'm absolutely delighted that the American Society of Comparative Law decided to devote a meeting to comparative legal history. But that leads us to consider what it is that we are doing when we engage in comparative legal history. The nature of the enterprise, what do we do, but also what ought we to be doing? What is the purpose of the enterprise? Not only what do we do, but also why? So this is a two-part question: the nature of the enterprise and the purpose of the enterprise. And I myself have written, and others have written, about the nature and purpose of comparative law, and about the nature and purpose of legal history. But today we're going to talk about comparative legal history, if indeed there is such a thing, distinct from the other two disciplines. And so we have on this panel three excellent scholars from different jurisdictions, three scholars whom I admire very much, three scholars whom I consider to be my friends, and three scholars who have written and studied on comparative law and have also written and studied on legal history, and perhaps on comparative legal history. But they will tell us that. And each will speak for 15 minutes. And then I will react a bit to what they have said and give them the opportunity to react to each other or to me. And I shall try very hard to save at least 30 minutes for the questions from the audience and for general discussion. So I'm going to introduce the speakers now at the beginning in the order in which they shall speak. The three speakers are Aniceto Masferrer, Ulrike Muessig, and Dirk Heirbaut. Professor Aniceto Masferrer is professor of legal history and comparative law at the University of Valencia. He is president of the European Society for Comparative Legal History, or he was until recently the president. He has visited Harvard, Cambridge, Melbourne, and Tasmania universities. He was a researcher at the Max Planck Institute für Europäische Rechtsgeschichte. And so I suppose he has a point of view, which we will hear in a minute. Professor Ulrike Muessig is head of chair for civil law, German and European legal history at the University of Passau, where she has also been the dean of the Faculty of Law. She has written widely on European constitutional history from the 12th century until the European Union. And she is a member of the Austrian Academy of Sciences and professeur invité at the Université Paris II Panthéon-Assas. Dirk Heirbaut is professor of legal history and Roman law at the University of Ghent. He is a member of the Royal Flemish Academy of Belgium for Science and the Arts, where I believe he is the head of the legal history group of that institution. And he's a member of the Academia Europaea. He was the founding vice president of the European Society for Comparative Legal History. So you see how fortunate we are to have these excellent scholars from Europe present to speak to the American Society of Comparative Law. And the first of these speakers will be Professor Aniceto Masferrer from the University of Valencia. Professor Masferrer.
Okay, thank you very much. So thank you, Tim, for this kind presentation. And I would say, I would like to extend my gratitude to the American Society for Comparative Law. It's an honor for me to be able to participate, although it is a kind of online conference. It is not the same thing, but anyway, it has advantages as well. One of the advantages is that we are here, all here, although we are in different places all over the world. So I will make some, in no more than 15 minutes, if it's even less, better. We'll have more time for questions and comments. So my presentation will be kind of an introductory presentation. In my land in Valencia, when we celebrate the feast of Saint Joseph, we have a lot of fireworks. One of the traits of the fireworks is that the nicest and most beautiful and even exciting part of the fireworks is the last part, not the first part. So this panel will be a bit the same. The first part is a bit less intensive, and then the other parts will be more interesting. Anyway, so the expression comparative legal history. This expression, it has a short history, in fact, a short history. It's quite new. The usage of this expression is quite recent, and it has spread in the last 2 decades, we could say. In an article or paper I wrote 2 years ago, I think, I tried to explore a bit this expression, where we can find this expression, when this expression starts or appear in the literature. And I came across one article of 1848 using this expression, comparative legal history. Then in the 20th century, but it was just an expression in the middle of the article. It was not an important expression. But in 1927, I found the title of one article with the expression comparative legal history. I found one reference in the 60s. In the 70s, we have more publications dealing or being concerned with the idea of comparative legal history, but not using the expression properly of comparative legal history. So then the question would be, this new expression reflects the existence of a new discipline? Do we have a new discipline called comparative legal history? Well, my answer would be no. More than a discipline, I would say that the expression comparative legal history is a reaction against the narrow nationalism and geographical segregation of legal history in contemporary European scholarship and professional organizations. So the expression comparative legal history is a way to emphasize the needs for a legal history with a clear comparative approach. Legal history and comparative law have very much in common. And one of the common things is the fact of having neglected a fundamental pillar of the disciplines. Comparative law somehow has neglected more the historical approach, and legal history has neglected more perhaps the comparative approach. The common factor of both negligences is to overlook something which is crucial about law. And this crucial idea is law belongs to culture. There is a connection between law and culture. And this connection has been misunderstood by both rationalists and historicists. And both contributed to a codification movement that gave birth to legal history studies, whose main purpose was the reconstruction, the exaltation, and sometimes even the glorification of national legal traditions. In doing so, culture or legal cultures were biased, distorted, and somehow even impoverished. It is possible to reconstruct an institution or give meaning to a text without the context? My answer is clear. No, it's not possible. Why should the context be then national? Some might reply, because we have national constitutions and we have national codes, and we should study the national laws. But I would argue it is the national approach the best or the natural dimension of law as culture? Does it make sense to limit the law to a so-called national culture when in some jurisdictions implied may imply the restriction of the plurality of laws, customs, or legal sources? Can a legal historian approach the Middle Ages without a comparative perspective? No. Can a legal historian approach the reception of jus commune in his or her own jurisdiction without this comparative perspective? No. Can a legal historian approach the codification of law or even constitutionalism without this comparative approach? The answer is no. Both legal historians and comparative lawyers should take more seriously, I would say, the cultural origin and dimension of law. In doing so, legal historians would work more comparatively, and comparative lawyers would enhance more the historical aspect of their research. Because in fact, I would say legal traditions are rarely national. Legal traditions are rather interconnected, interdependent, and mutually influence each other. So taking seriously the law as part of culture implies the recognition of an important trait of human nature, that some aspects are common to most cultures and others differ from one culture to another. For a Roman lawyer, the reception of Roman law would be a common phenomenon of the civil law traditions. In fact, the scholars who cultivated quite a lot the comparative approach was precisely Roman lawyers. So how a Roman law institution operated in the Roman law period, in the Roman Empire, and how these institutions and these sources operated in other geographical and chronological contexts. So in fact, 5 minutes ago, when I was referring to this article of 1848, it's a German article published in that year in the Zeitschrift für Deutsches Recht und Deutsche Rechtswissenschaft, and it says something almost literal. I translated from German into English. It says, comparative legal history enables to ascertain which phenomena depend on the general course of all cultures and which on particular influences of nationality, climate, and other special circumstances. If that statement was written in 1848, 1 century before that, exactly when Montesquieu wrote The Spirit of the Laws in 1748, he said, admitting that the laws are received from nature prior to the establishment of societies, he stated that, and I'm quoting, the political and civil laws of each nation should be adapted in such a manner to the people for whom they are framed, to the nature and principle of each government, to the climate of each country, to the quality of its soil, to its situation and extent, to the main occupation of the natives, whether husbandmen, huntsmen, or shepherds. They should have the relation to the degree of liberty which the Constitution will bear, to the religion of the inhabitants, to their inclinations, riches, numbers, commerce, manners, and customs. In the end, they have relations, he wrote, they have relations to each other and also to their origin and to the intent of the legislator and to the order of things on which they are established, in all of which different lights they ought to be considered. So this means that then culture in general, and law in particular, I would say that that is necessarily contextual, related to a context without which both culture and law do not make any sense. So legal historians need to combine more the chronological context with the geographical one. And comparative lawyers need to combine more the geographical context with the chronological one. So with the expression comparative legal history, I've never intended to claim for a new discipline, but for a renewal of a legal history to attach to national legal tradition or national legal cultures. The name of the European Society for Comparative Legal History, in fact, was notably discussed in the founding meeting of the Society in the 5th December 2009. Because some people said, well, this is a society for legal historians. If we put comparative legal history, it would somehow be an obstacle for some legal historians to join us. This may be an obstacle. We should take this obstacle away. But some people thought that it was important to emphasize this idea, this important idea that legal history should not be something with this national narrowness. And we voted. It was a huge discussion, and we voted and gained this idea that we should put the idea of comparative legal history, which doesn't mean that comparative legal history is a new discipline, different from, of course, legal history. Well, this discussion didn't appear at all when 2 years ago, or 3 years ago, 2 years ago, or even the discussion started 1 year after that, we discussed the foundation, the creation of the journal, the Comparative Legal History Journal. Nobody said anything against this name, Comparative Legal History. So I would say, and I have to finish because I think I've always finished my time, almost finished my time. I think that the impact of both the society, well, not both, because in fact there are three elements, important elements. The impact of the society with the journal and the blog. Well, the society has already organized many things, but 5 already biannual conferences, different postgraduate conferences. The journal, 2 issues every year from 2013 till now. The blog, we know that it has had almost 1.5 million page views from its existence. And there are something like 20,000 page views a month, which is quite something it is. Well, all these tools or instruments have been quite useful in promoting and spreading a legal history, a scholarship with a wider view. And I think it is quite impressive, and it's thanks to the contribution of many legal historians who somehow share the same things I'm saying here. They are not intending, they are not claiming that there exists a new discipline called comparative legal history. It's the discipline we know, which is legal history, with a wider view and with a much more focus on comparative perspective. So I think the European Society for Comparative Legal History has served, and I would say is still serving, and I think it will serve in the future to enhance comparative legal history all over the world. Thank you very much.
Thank you very much, Professor Masferrer, for those very illuminating and insightful remarks. And now I will call on Professor Ulrike Muessig for her remarks.
Thanks a lot. Thanks a lot for the American Society of Comparative Law for accepting me as panelist here. Thanks for the invitation of my fellow and friend colleagues here on this panel. I'm really honored to contribute here. To the nature and purpose of comparative law, Gustav Radbruch is heard mourning that, I quote, science which have to busy themselves with their own methodology are 6 sciences. Though generally true, it is no helpful diagnosis for our purposes. Comparatist historians are normally curious, which is their key virtue, listening to Samuel Johnson, who confirms, I quote again, that curiosity is never more agreeable or usefully employed than in examining the laws, and I added historical laws and customs of foreign nations. If there is a sixth science in the Radbruch sense, it is not comparative legal history, but rather legal science, or you could add legal history, which does not know what to compare. And this leads me to my first heading, the challenging nature of comparative interests in legal history. Incomparables cannot usefully be compared, and in comparative legal history, comparables are those which fulfill the same function. This is one of my core elements. Similar institutions, though, might be false friends, and therefore an institutional focus still reflecting some traditional historiographical interests in the political unity and social order of a particular state are not appropriate neither for the nature nor for the purpose of comparative legal history. What the nature of comparative legal history requires, therefore, is the focus on functionality, which crosses the institutional limits of a traditional national historiography in a way that recalls us to Isaac Newton's metaphor of standing on the shoulders of giants. Within our context here, Newton's metaphor has a greater meaning than simply a gesture of admiration for the great minds earlier than our own times, like my admiration for my fellow speakers here and for my president. Rather, it alludes to the legal struggles at the time of founding the classical mechanics. Newton's law of universal gravitation explains the necessity of falling bodies without the need of any prerequisites, and was formulated at exactly the time when legal minds tried to explain law in the same manner, its validity and effectiveness, irrespective, and this is important for me, irrespective of any religious, moral, cultural, rank-related or economic preconditions. One of these efficacious natural scientists of laws was Thomas Hobbes, a mathematician by training, Oxford mind, according to whom not jurisprudentia, all of you might know this quote, not jurisprudentia, but command makes the law. Seeing further by standing on the shoulders of giants in the comparative context means that justice is not done merely by the order to apply the law. So I'm of course not following Thomas Hobbes if I'm standing on the shoulders of giants, but by the functions fulfilled by legal remedies. And I will try a lot to persuade you on this focus on functionality. One could easily object such a plea for methodological focus on functionality by a presumptio similitudinis, so a presumption that the practical results of similar institutions are most likely similar, and that along this line one should find what one searches. But I would be most alert to be guided in a comparative research by the results I will presumably find. As Keith Barker has warned, I quote, "The search for origins can be hazardous. Above all, such a presumptio similitudinis of similar institutions risks the pitfalls of hermeneutic misunderstandings." This was one of the topics of the first plenary session, which challenge all comparative historical research. If we take, for example, the ordinary judge, and all of those who know me quite a while won't be that surprised that I choose the ordinary judge, it is true that many texts across the century have references to such an expression. But the literal meaning of this term is not a fixed idea. Moreover, historical understanding does not remain unaffected, and this was point of the argumentation of Seitu, by the modern conceptual, cognitive, and linguistic world of those who seek to understand the past. So you always have a contexted mind, be it in the past or be it in the present. So this unavoidable presentism, the reconstruction of the past realms in the present, risks revealing connections explaining the past that were never perceived or intended in the past. This hermeneutical gap between the historical author of the source and the later interpreter is insurmountable. The historian can only read sources in the context that they are historical, or rather, can only conceptualize the past by using the present as a frame of reference. As Hegel noted, the owl of Minerva begins its flight only with the onset of dusk. Thus, any attempted representation of the past based on linguistic usage is at best an illusion. So I wouldn't have done a great job if I stopped my paper here. In addition to the hermeneutical pitfalls of historical research, so to speak in the vertical sense, comparative historical research faces hermeneutical deficiencies between the different legal systems, so to speak in the horizontal sense. The origins of our example, take the ordinary judge, is enshrined in the deviating development of different legal systems. All of you know that the most relevant legal terms, take judge, law, legal, court, competence, judicial proceeding, among others, are interchangeably in different sources. So you'll find them in many, many sources. And indeed, they hold different meanings even within their own language. As Aniceto has put it, that law has this strong connection to culture and therefore is just a linguistic product. If we are naughty on this point. This was recognized by the legal philosopher Hermann Kantorowicz, who in his influential The Definition of Law began by demonstrating that defining law as an exact term is markedly more difficult than it might at first appear. The problem, as he saw it, is that, I quote him, the most dangerous enemy of science is that unfaithful servant and secret master of thought, language. Having said this, the points of comparison have to be abstracted somehow from the wording of historical guarantees or from the proper assets of historical institutions. Lumping together all guarantees or institutions would never clarify common traditions or distinct developments. The quality of the brandy is not determined by the ingredients, but also by the distiller's skill. And in this sense, the wording of the guarantees or the institutions as such cannot be compared. They cannot be isolated from their historical juridical contexts. Rather, the appropriate tools for historic comparison has to be found on a different level. And this leads me to my next section, the methodological tools of functionality. If language affords only confusion, there remains one further avenue of inquiry available to us. In this, again, Kantorowicz also offers a suggestion. Before searching for the meaning of law, he argued, one must search for the meaning of the meaning. Most frequently, the meaning of a legal concept, that is to say, its actual effect and impact, can be determined by usage. Intent might be so abstract as to be unknowable, but the circumstances in which an argumentation is utilized allows us a frame of analysis. This also permits us to analyze laws, legal arguments beyond their written form, thus allowing to approach what Kantorowicz would call their meaning, or good old Montesquieu, called the spirit of the law, which I redefine in my paper and in many of my writings as the conflict situation. So in the precise aim in which a legal argument is used, a legal claim raised, or a legal guarantee is formulated against. This orientates the focus on concrete problems, in other words, in conflict situations. And the historic intentions to solve concrete conflicts, this is what I call protective rationales. So this is what legal remedies try to achieve. And in the end, those protective rationales, they are my tool to compare. Then I'm above this pure wording scheme. I'm not looking for false friends, and I compare institutions or legal remedies or developments on the function they had within the discourse or within the developments. Yeah, so these are my central elements to explain the idea to use functionality of the legal institutes as tertium comparationis, so as this level to compare things and to make the functionality even more precise within the context of conflict situations. So law always wants to solve any problems. Why not take the most problematic of those problems, which means to solve conflicts? And within these conflicts, the legal remedies offer sort of like their skeleton, what they want to be used of. If you remember my beginning, this is what I meant, not the abstract idea, but the concrete usage within a conflict situation. Is that what I plead for should be the common ground as a tertium comparationis? This leads me to the purpose of comparative legal history. So first we had the problem, now we've got the purpose. As much as the judges, administrators, and governors' position with the national legal traditions vary vastly, so too does the idea of justice coincide in the same principle. The core element, and now forgive me that I take this European view, so the core element of European procedural laws, the medieval canon law complementarity of procedural and substantive justice, seems to be the legal implementation of the antique suum cuique, to each his own. So if you think in what I try to develop as the method of functionality, you could say, well, the most general function that legal remedies have is to provide justice. And if you put justice, or to provide justice on a very general scale, to make it comparable between different legal systems, then you explain it, justice, as being the legal implementation of the suum cuique. So I'm doing nothing more than just to apply all my arguments beforehand now to the idea of the purpose of comparative legal history. The initial wording of the Institutes of Justinian, so I'm not inventing anything new, held that justitia est constans et perpetua voluntas jus suum cuique tribuendi. So justice is the persistent and constant will to give each one his right. This stood as the legal program for all emerging jurisdiction throughout early modern Europe, and I would assume perhaps also for other jurisdictions all over the world. The continuity of this antique suum cuique, to each its own, with the Aristotelian demand that equals be treated equally, that unequals be treated differently according to their differences, seems obvious. And now there's a painful point, but I feel the responsibility also to make that, especially as a young, or well, not that young anymore, a German academic, the perversion of the suum cuique in the 20th century, most notably in the use of the phrase "to each his own," jedem das seine, by the German nationalist socialist regime on the gates of Buchenwald concentration camp, demonstrates the wisdom of Radbruch's claim, and we started with Radbruch in 1932, that justice also has to reach beyond a formal suum cuique. So we're still within this sort of like function of legal remedies, and on a very abstract scale of purpose of comparative legal history, designed as a response to the ease by which the Nazi regime seized power in an outwardly legal, though not just manner, which is a painful asset to realize as legal historian. The Radbruch formula that extremely unjust law is not law. So law can also lose the function to provide justice, is a shorthand example of Radbruch's broader idea of law, a shift to a neo-Kantian concept that law is defined by a triad of justice. So now I'm enriching the functions. The triad of justice, suitability for a purpose, and certainty. And to be very frank and free, this kind of suitability and purpose is nothing else than that what I call functionality, substantiated in conflict situations. I'm already run out of time. May I be very, very quick to round that up?
Yes, of course, please continue.
Okay, so according to Radbruch's formula and this conceptualization of suitability for a purpose and legal certainty, and this is another, I think, very important idea. The suum cuique is only valid and resilient if embedded in a normative individualism and altruism as benchmarks of justice. So legal addressees as persons and entities, and the scale to which the decisions are made is based upon the interests of the legal addressees and not on the interests of the decision maker. And this perspective to the addressee seems, from my point of view, highly relevant and makes comparative legal history all the more convincing. Thereby, one could sum up, it is the main purpose of comparative legal history to provide results with a perceptibility of justice. Justice has not only been done, but seen to be done. This is one of those famous sayings of common law, but if you really go for comparative legal history, you could bring that into life. I come to my end. Rather, comparative history provides what persons seeking justice feel to be a just decision in their case, be it for a murdered son of the widow in front of the Emperor Trajan, or for a broken mug after unmasking a corrupt judge. Dante and Kleist, though centuries apart from different background, are companions in formulating the primary human longing for judicial justice, and especially for justice seen to be done. So if you follow my ideas of functionality, substantiated in concrete conflict situations, if you also look to the limits of functionality in accordance to the Radbruch formula, you can realize that the protective rationales of legal institutions, rules and concepts always correlate to the party's trust only in justice apparent. Thereby, comparative legal history points to a steadfast trust in the specifically law-related idea of justice. An issued, be it administrative, judicial, governmental decision, is perceived to be just on the basis of to each his own, if guided by normativity and provides legal certainty. In doing so, comparative legal history provides the basis 4. The legal doctrines at the core of communities, which take justice to be fair and just foundations of society. And such a general statement beyond legal science is neither a delusion of law nor legal concepts of justice, but rather emerges from the methodological need and innovative force of comparative legal history to look beyond the institutions. I thank you very kindly for your attention.
Thank you very much, Professor Muessig, for that clear, learned, and thought-provoking remarks. Now we turn to Professor Dirk Heirbaut for the final presentation, after which we'll have some discussion. Professor Heirbaut.
Thank you, Tim, for the introduction, and also thanks to you and to the organizers for the chance to speak at this conference. Now, I must say, I will start with somehow contradicting what Satu has been saying, but it is because he has been presenting the whole story as a reaction against national legal history. But I am Belgian. National history in Belgium. Even as a student at the university, I didn't even have a class on the history of Belgium. That only came later on. That's something very, very recent at my university, for example. And national legal history was something I didn't know that either. For example, in 1999, I was asked to write the historical chapter for an introduction to Belgian law. And I thought, oh, well, this will be easy. I will just take a few other books that have been written on the subject. I was looking for them, and I couldn't find any book that covered the whole of Belgian legal history from, let's say, the Middle Ages until the present day. I still had to write something completely all on myself. So it's different in my country when you talk about comparative legal history as a reaction against national legal history. I would rather say we have only recently started with national legal history as a reaction against comparative legal history. And if you look at it, for example, well, Satu has mentioned the European Society for Comparative Legal History, established 2009. Well, but this was not the first society of its name. And of its name, yes, but not of its kind, because from 1935 on, in Brussels, there is the Jean Baudin Society for Comparative Institutional History. It's not called legal history, and that's why it's a bit misleading, because it was actually legal history, in my opinion, under the direction of John Gillison, a Belgian professor. The society organized conferences on lots of topics of legal history, and it was things like, let's say, the legal status of women, but also the great empires, things like that. And then you had country reports, then you had reports bringing everything together for a part of the world, and then you had the truly global reports trying to define the subject in a certain way, or at least after all these separate studies, to come to some kind of common definition, concept, whatever it was, of what they had been studying. Now, I do not mention this society just for historical reasons, but also because the transactions of it have been published, and they are still very interesting literature. And not enough people are using this. So I would really call people to look into that. But one of the problems with the society was that Gillison, who had been leading all of it, he died in 1988. And then the whole idea died out a bit with him. So the society stopped in 2000. And then when you have in 2009, the European Society for Comparative Legal History, for me, that was not something new. For me, it was a renaissance of an old idea. And I was very glad that the new society filled that gap. But you have to keep in mind when speaking about comparative law that I come from a Belgian context, and that for us it was different. Also, for example, my teacher was Rauw van Kanehem. For him, comparative legal history was so self-evident that he never even mentioned that it was comparative legal history. So I really come from a different background there. And one of the questions you may ask is, why then were all these Belgians, but not just Belgians, but also, for example, Dutchmen or people from the Nordic countries, why were they all so much into comparatively doing legal history? Well, the size of the country. If you have a great country, you have a great legal history, and you have lots of things you can do in your own country. If you have a country like Belgium, well, wherever you start with your car in Belgium, no matter, after 3 hours of driving, you're always out of the country. It means that we have a small country and you need to look abroad if you want to study something. Add to that until the 1990s, most Belgian legal historians were still medievalists, and we used to have in the Middle Ages about at least, that's the least we know, 600 different legal systems. So if you study one of those, it's a really very small jurisdiction. So you will not have that many sources. In order to study it well, you need to look at the neighbors, and it was also what was done at the time in the Middle Ages. Satu has already referred to that actually. So that was one of the goals of comparative legal history, and has always been, if you do not have enough material, you can plug up the gaps with what you find in your comparative material. That's an important purpose of comparative legal history, but to me, even more important is comparative legal history is our laboratory. We don't have a lab situation where you can really experiment with people of the past. They are dead, they remain dead, and we cannot change that. We cannot have an experiment with them, but we can use comparative legal history as a laboratory of legal solutions. And I want to offer a few examples of that. For example, it can be now that as a law scholar, you are confronted with a completely new situation for which you do not find, for example, an equivalent today. Let's say you have a debate on unification and codification of private law in Europe. Do we need a European civil code? Now, whether we do need one or not, that's not the issue here, because that could take us a long way. But suppose you want to study that, then you have a problem. Well, where do I really find an equivalent, something that can show me what the challenges and opportunities are? You could, of course, say, look at the Uniform Commercial Code in the United States, but that's not really a codification in the sense of a state-made text. There's other examples. You could look, for example, at Switzerland, which has even recently unified its procedural law, very recently. But there you have to admit that quantity has a quality all its own. And well, in Switzerland, you can still say as one person, I know all of the Swiss procedural laws. That was still feasible. It's not feasible to do that for the whole of Europe. So you need to look at an other element for another entity for comparison. When I was doing that, well, I said, let's look at 19th century Germany, which was confronted with the same problem of unification and codification. And I found then many interesting things, which refer actually to some of the issues already mentioned by the previous speakers, like the functional elements and the contextual elements. What I found was that all of the similarities were actually functional and all of the differences were actually contextual. So it was actually quite easy. But there's even more than that, and that's something that is related to another problem. As we all know, if you study history, path dependence plays a role. So certain roads that have been taken in the past, decisions that have an impact on what happens or can happen in the future. If you did A, B will become easier, for example, but C will become harder to do. Now, one of my problems when I teach that to my students, when I teach them the methodology of legal history, is that they say, oh, that's actually very easy. B comes after A, so B was necessary. That's of course not path dependence. That's chronology, and that's something else. The problem is how to avoid falling into the trap thinking that chronology is path dependence because A comes after B. It should have come after that. No. Well, you could do that with several techniques, like, for example, process tracing from political science. but I'm not going to look at that now. Another element could be counterfactual history. Now, counterfactual history, let's be honest about it. As soon as I mention that, everyone has a big smile, thinks, oh, that's nice for fantasy, but that's not real science. Well, I can imagine that indeed all these speculations about what if that's not really for science, it leads to great TV series and so on, but that's about it. Yes, but there is a way of doing it in such a way that it does not become the fantasy of legal history, and that is comparative legal history. If we want to study the impact of a certain factor in a certain place, we can look at another place nearby where that element has been absent or at least less important. Just an example, at one moment I wanted to look into the attitude of Belgian judges during World War II towards the German occupation authorities. Now, what I found was that actually World War I played a role. In Belgium in World War II, it was like, oh, they are here again. Ze zijn weer daar. And what they did was, what did we do the last time? They took the scenario from that and they repeated it. Now, in order to confirm whether actually this had been the case, I looked also at the Netherlands, because the Netherlands had not been occupied during the First World War. And indeed, you saw a difference there that explained that First World War had made a difference here. So it is not, of course, unconvertible proof, but still, it helped along. And in my opinion, one of the nicest examples of a counterfactual history, actually comparative legal history as counterfactual history, is English common law. If you want to know what Europe would have been without the jus commune, we have England. And of course, it's not without the jus commune. That's not true, but at least with a lesser impact of the jus commune. Now, there's been enough done about that, but what I find the most interesting is where you have these entangled histories where a region moves from one country to another, and to make it even more fascinating, sometimes back again. And then, of course, there is a nice example of shared Franco-German history, and thus Alsace-Lorraine, Alsace-Lotharingen, which in 1871 becomes German, and then 1919, with the Versailles Treaty, returns to France. Now, you do not have to ask what would have happened if in 1871 the Germans would have conquered France and imposed their law. No, you have a part of France where that happened. But it's interesting because this has an impact beyond that even. And sometimes, and that makes it also interesting, I think, for comparative lawyers, they tend to forget these interesting cases. Because, for example, in France, they've always called this local law. They never wanted to call it German law, but actually in 1976, when you had the new Code of Civil Procedure, it was a unification of French law based to a large extent on German law, but no one ever called it German law. It was just local law of France. So this is somewhere where I think that comparative legal history can be very interesting. It's a nice intellectual exercise, and that's always great, but it can also help us better to understand events by looking into a mirror of what might have been, and thereby better understanding what happened. So legal history does not just, comparative legal history does not help us to appreciate the legal system's history for its own sake, but also it teaches us a lot about other legal systems. Now, I want to abuse this occasion to plead for something. And when I just said that comparative legal history is a mirror, sometimes it's a mirror with a lot of cracks in it. And the cracks are due to the two societies actually that I mentioned, or they're not due to them, but somehow they epitomize them, they symbolize them. The old Société Jean Baudin, and I now use the French name, not the English name, but the old Société Jean Baudin, one of the reasons that it broke down was that it had started with French as a common language of academia. And of course, that was no longer possible. And there, of course, then the new Society for Comparative Legal History could take over by using English. And you could really see that it has given a boost to the study of comparative legal history in Europe. Before that, you had Deutsche Rechtshistorikertage, you had the French Journée of the Société d'Histoire du Droit, you had the British Legal History Conference. We also had something like that in Belgium and the Netherlands in Dutch. And now, by using English, we can all meet one another and overcome that isolation. However, that has a very important danger, and that I see in a lot of literature, that is that internationalization sometimes means monoculture of English. And I have an enormous problem with that. Now, I know that here I am preaching to the choir, because if I look at the names, most of the people now listening will be working in several languages. But still, it's something that we need to make our colleagues more aware of, that comparative legal history also entails reading the literature in several languages. Because what sometimes happens is that you have to read things like, this happened for the first time in England because the author has already been reading books in English. And that then you, as not as a reader from another country, think, oh no, this already happened in Germany in the 17th century, things like that. One of the best examples, of course, is when all these Englishmen are then extolling Magna Carta, the Great Charter, and then I'm always thinking, oh yes, they came after Spain, and we had something like that already in Ghent in 1128. So to me, they're just Johnny-come-latelys. So I think we really need to emphasize that aspect also, that comparative legal history cannot be a monoculture of English, even though I am now saying this in English. So there is a certain irony in this. Thank you all for your attention.
Thank you very much. Thank you very much, Professor Heirbaut, for your reflective and pragmatic observations. With the end of your remarks, we come to a turning point in our session, because now we're going to come into a more general conversation. I'm just going to say one or two words by way of summary, and then I'm going to invite the speakers to say one or two words by way of response to the provocation. But in fact, we're saving the remaining time for a general conversation that should include the audience. And therefore, first of all, I'm going to invite the audience to make their faces apparent, unless they for some reason wish not to. But that way, and I think that's possible, try it anyway, see if you're able to make your faces apparent. Yes, okay, at least one person. Good to see you. And I ask you to do that because then you become equal participants in this conversation at this point, and we can see you and we can feel ourselves to be part of a group. Yep. And when enough of you are apparent, I want you to take advantage of the fact that we can see your faces to join me in applauding the excellent talks that we have just heard. So let's.
Thanks. Yeah, you're welcome. Very welcome.
So those were truly excellent and inspiring talks, and they made me think very much. And all of them had both of these elements that we mentioned at the beginning, because on the one hand, they were sociological in that they were descriptions of comparative legal history. And on the other hand, they were also normative in the sense that they expressed a point of view about what it is that comparative legal history should be. And I'm just now going to mention a few of the points that struck me in each of these collections of remarks. And you can, and I'm sure that my inaccurate observations will provoke some interesting reflection by our panelists. So Professor Masferrer said, I think, that legal history is necessarily comparative. The culture of law is never and never has been just national, nor should it be. And when we try to limit our study of legal history at the border, that leads to mistakes, it leads to ignorance, it leads to false history. So legal history must be comparative in order to be good legal history. Professor Muessig reminds us that the past, of course, had a different context. So history always has an inescapable presentism, because we can only understand the past in the light of the present. And even legal terms have completely different meanings at different times and even at the same time. So there's an unavoidable distance. So comparison, when we do it, is most effective when it's abstracted from language and made functional. And in discussing what that function should be, I think ultimately it came down to the purpose of law itself, which is justice. So we ended up discovering not only the nature and purpose of comparative legal history, but also the nature and purpose of law. So this was a very helpful observation. But this concept of justice as being the organizing purpose of our enterprise, any legal enterprise. And then Professor Heirbaut spoke about national legal history. In fact, the observation that Professor Masferrer warned us against the excessive nationalism in legal history, is not a problem that you're going to encounter in Belgium, because there never was particularly that attitude. All Belgian legal historians have always done comparative legal history, just as all Belgian lawyers have always done comparative law, because it's inescapably the case that they are participants in a comparative enterprise, whether they wish to be or not. And I think this is perhaps not such a disagreement with Masferrer after all, because he said, that's true everywhere. That's true everywhere. Lawyers everywhere have to be a participant in an international conversation if they are to be intelligent and effective lawyers. Of course, this is easy to say at a comparative law conference, but I say it anyway. And one of the benefits of this is precisely this counterfaction, we talk so often about what if we had taken this turn, what would have happened? And in comparative legal history, in fact, sometimes we do know what would have happened. Just as in the United States, we see different states taking different roads, and we can see the different effects of these different roads. So too, throughout the world, we see these different roads actually taken with different effects. So, so I thought each of these talks was highly provocative. I think there were significant elements of overlap, but also significant differences. And I now want to give the speakers again an opportunity just briefly to react to what I have said and to what each other have said as a way of provoking our audience to participate in a more general conversation if they wish to. So again, I suppose in the order in which you spoke, Professor Masferrer, do you have any observations?
Well, the only thing I would say very briefly is that I don't think there is a disagreement between Dirk and myself. I think what Dirk said is precisely the exception that confirms the general rule. This is not a disagreement. I think he somehow completed what I said.
Professor Muessig.
Yeah, may I bridge the gap between you, Seto, and Dirk? I would say, as Dirk's argument was always, well, the Belgians need to be comparatists because they've got such a small country. If you look down to all the 19th century discourses, for example, in St. Paul's Church, the Germans, well, they always ended up not to know who they are. So they always had to struggle which territory to bring in and not, and to look outside to the like the Belgian constitution or a French institution. Well, we don't want to have French institution. They admired all those English administrative stuff. So I would be so naughty to say there's no difference between the comparative need between bigger or smaller countries. Well, you do comparative legal history anyway, especially if you look to legal sources. So coming back to your well, it was a perfect summary of what I tried to lecture on. I think it's, yeah, for me, the most important thing if you do comparative legal history is to be very clear what point you compare, and that you're not choose incomparable false friends and then trying to elaborate any literal similarities, which in effect don't prove any similarities. And this is what this search for functionality is about. And to make functionality or function even more precise means to try to connect it to concrete situations. And therefore I went for the conflict situations. And then in the end, and this is what I really liked on your summing up, Tim, to say, well, in the end, it's always the question for for justice. What I'd really love to do, and perhaps this is the perfect audience, I always feel if we go to this abstract level of justice, even then there must be differences. So it would be marvelous. I always have the impression that there is a very specific European thinking that you trust rational law, and law could be just if it's trained academically, if it then it's used rationally, then you could trust the letters of the law. Somehow this is a kind of, I don't know, it's a blind trust into rationality. And I think it would be marvelous to question this very specific point, European point, with Asiatic, with African, with Southern American, perhaps with Northern American. I'm not sure whether you've got a very specific American tradition to define the function of justice, and to bring that together and to make that on a bigger global scale. Yeah. I don't really know how to answer your question, because I felt it wasn't really a question, Tim. But I'm happy to answer whatever you want to know.
Well, I should give Professor Heirbaut a chance to say something, and then we go to the audience. And when we
I
come
think
to
it's just that our answers and also our lectures somehow reflect our national legal cultures in some ways. If you said, I've been more pragmatic, well, that's typical for all Belgian lawyers. And Ulrike was more abstract, well, that's also typical for all these German lawyers, I would say. And I leave it to Seth to decide whether he's a Spanish or a Valencian lawyer or a Catalonian lawyer. I leave that to him.
Yeah.
Okay, well, thank you very much, my friends, for your wonderful remarks. And what I want to do now is to throw it open to the audience. And I think there are few enough people in the audience, so I ask them both for questions, or if they wish, for observations or statements. It becomes a conversation now. And if you wish to speak, for those of you I can see, you may simply raise your hand, because I can see you. And for those of you I cannot see, there is a raise hand function in the Zoom that you could use. And so I ask if anyone in the audience has any observations or questions that they want to raise at this point. Professor Bignami, and you should unmute yourself.
So, thank you very much for these fascinating presentations. I am not a historian, but I am a comparative lawyer. And the question actually goes to Van Keneghem, whose name I'm butchering right now. But I ask because I've started to use him when I teach comparative law. And he's very useful in teaching comparative law to an American audience, because my impression is that he's willing to speak at a level of generality that many historians are not willing to speak on. So he has an explanation for the rise of the differences in style between common law and civil law, which goes to essentially William the Conqueror and the different timing of the rise of the English system vis-a-vis the continental jus commune system. And that goes basically for every aspect of what we think of as the difference between the civil and the common law tradition. So it's a timing argument, and he makes it, and it's very compelling for the students, and it's nice and simple. And then he also is willing to start, he has one of these short handbooks he did for students who were studying, I think, on a Erasmus program, where he asked,
That was when he was teaching in Maastricht. That was when he was teaching in Maastricht.
Yeah, okay. And so, and it asks, which one's better, judges, legislators, or legal scholars? And so you ask the question, and so I can ask my students, which one do you agree with? So basically, it's a way of getting them to think, okay, which one is better? Not like it's really a viable kind of proposition for anybody to think of, because it's not like you convert from one to the other, but they can actually tackle the problem in a very concrete, normative way. So I guess my question is, is that unusual for legal historians? And am I wrongly assuming that that's something that many legal historians, and the kind of argument that tends not to be made today in the discipline, because it's so much more fine-grained and attuned to all the particular contingencies, and I guess, as the second talk mentioned, the way in which context is so important. So it's really hard to make those kinds of arguments, causally speaking, as well as ask for normative assessment. And so, yeah, I think it's more curiosity, how he's considered within the discipline.
I must say there that I've recently published an article on his philosophy of legal history. So his views on how to do legal history. And so the whole explanation is there, but I can give you some, but you need to keep in mind the two books that many people are using, like the one you use, Unity and Diversity, European Law in the Past and the Future. Actually, those two books were based on lectures for very small groups of select students. And that was not his ordinary teaching. His ordinary teaching was more like the whole chronology thing. And whereas for those groups, it was really cherry picking. And that, of course, makes his books also so nice, because you have someone who has a decennia-long experience, and then he goes cherry picking. And then there's another element. He was very much influenced by Max Weber, and he wanted to look for patterns and things like that. Yeah. And so what he did was all the time looking for his patterns. And then he had a bit of in my opinion, a confirmation bias, because he was looking for things that could prove his theory. But sometimes then he had things that were contradicting it. And then he had a problem, how to solve that. And then his deus ex machina was chance. He says, well, chance always plays a role. My opinion would then be, no, it's not chance. It's just that there's more factors than that you have taken into account. But if you reduce things to a model, then always, in order to have your model, you leave things out, because that's what you do when you make a model. So, but still, those books are indeed fascinating, because we had them in Ghent, the students also, and then there was the ordinary books, and then you had a specialized class, and there it was the cherry picking, and that was a lot more fun. So the judges, legislators, and professors, I had that as a small class with only 3 students, and then Van Kanem and just us debating with him. And that was, yeah, great.
Thank you. Thanks.
Are there another question from the audience? You should, I will say that people should have anytime you have a question, simply raise your hand or put up the raise hand symbol. If you don't have a question, then I'll start asking questions, which will make everybody suffer. But I think I'll do it anyway, because I was provoked to this. Of course, Van Hanegem is a very great man, a real inspiration in more than one field. And the great tradition in Ghent reflects that, the continually great tradition there. But I was struck by something that was said by Professor Bignami, which is that there is this, he takes the big picture. He looks for, he looks for fundamental, he looks at fundamental questions and looks at the big picture and does that without fear. And I think in my eyes, that is something that is incredibly laudable. I sometimes worry that our attempts to contextualize make it impossible to achieve anything useful. And one of the values I see in comparative law is its practical utility. And this is sort of what you said, Professor Heirbaut. I think there is a practical utility to what we are doing. So that's one way of looking at it. And then I want to come back to Professor Muessig, because when she talked about the purpose, she mentioned justice. And again, this is a very big picture, but something that was very persuasive to me. So to what extent do you think it is legitimate, as Professor Bignami, I think herself, is also doing now, to ask your students these huge questions, questions for which there may not be an answer, but making your students, or through your books, making your readers grapple with these really fundamental questions about the usefulness, the effectiveness of law. Professor Muessig.
Where shall I start? I think it's always good to to apply the law after you have thoroughly thought about it. And I think this is one of those great impacts that both comparative law and legal history, and perhaps also the combination of the both, can have. That if you, well, Dirk, he says it's like cherry picking. If you use arguments from other foreign countries, well, this was also addressed in the general panel, what we had just before, or if you can draw an argument from previous centuries, or even combine both. This is what we are meant to do in the comparative legal history. And you provoke the students to think sort of something beyond applying the mere text. Well, somehow for me, this is the essence of academic legal training. Otherwise, well, there was a lot of rumor about the English now on the island. You could also have them just going to advocates and learning cases by heart. And it's not that I don't admire this technicalities of common law. I studied in Cambridge myself and I loved it there. And Tony Weir, he was my teacher, and I think I would also praise myself of a kind of friendship with von Hanegem. This is the great advantage of comparative legal history, that you bring, that you introduce a reflective niveau, how to apply law. And well, I felt tempted also to say what you could reach if you simply apply law without thinking on the impact, on the unjust impact it could have. So I think it's a kind of responsibility that we have as academic teacher to make them think what they are doing.
Professor Heirbaut.
If I may add something to that, one of the important things I noticed is that what people like from other sciences is that you have sometimes big ideas, and okay, you may then make some mistakes about the details. And one of the problems that confronts us as a discipline is if you have these big ideas and then there's peer review, then you will inevitably have a peer review that says, oh, this small detail is not right, this small detail is not right, this and that. You can forget about it. And what's the problem with that? Thereafter, you see articles like the one you have been thinking being published by, for example, political scientists, philosophers, sociologists, and so on. Because in the previous session, Mark Bloch, for example, was mentioned. Well, but the great strength of his book, for example, was that a lot of it, and I know few do it quite well, was not really right, but it inspired people. And there we should also be a bit more forgiving towards colleagues, I would say. Sometimes it's better that someone has a great idea, admitting that sometimes precision has been sacrificed, but still it will inspire, because the danger is that what you see is that you get all these detailed studies. It's something that, for example, I notice when it's done by jurists, at least, in the study of Roman law. It has become a study of details in many cases. And then you read articles about, yes, in the Mommsen edition, there was someone who put there, they had put at one moment a point there and it should have been a semicolon. And then you read a whole article on that. And I'm really thinking, oh gods, what does this serve? This does not inspire me. And we should also have a bit more of a forgiving spirit for colleagues who really want to break everything open. And sometimes, yes, they may crash. But if it advances our knowledge, why not?
Professor Masferrer.
Well, I think one of the nicest things of legal history is that it gives you a historical perspective that enables you to try to answer difficult questions. Because of course, law is a practical thing. Roman law was a very practical law. So let's solve the specific problem we have. That's clear. But this practical thing should be compatible somehow with a purpose. Law has a purpose. And the purpose of law is to build, I would say, peaceful and fair societies. So you need to try this. Even Montesquieu, when he was talking about the variety of laws depending on the political government and the climate and all these things, he said in one of his chapters, precisely discussing the French and English systems for punishment of false witnesses, he advised that to determine which of those systems is most agreeable to reason, we must take them each as a whole and compare them in their entirety. So if you want to do that, of course you need comparative law, but you need also the legal history. So because, I mean, the kind of judgment you are trying to do is quite serious. You are reflecting whether this legal system, this institution, is more agreeable to reason than another legal institution. I think one of the nicest things of a legal historian is try to help students to think about difficult matters. Even somehow, law professors, we don't have the answer to that question, but this is something we are looking for, something we are seeking. And in fact, this is the purpose of our scholarship. Our scholarship somehow pursues to find answers to difficult questions. It's not just a functional, practical, a mere functional, practical activity. It's something which goes beyond to practicality, I would say.
This is a very...
Even to understand some things. I mean, always we have been, I would say, sexual crimes, for example. But there's nothing to do I would say, the philosophical and cultural framework of sexual crimes in the 18th century or after the revolution, the sexual revolution in 1968. It's completely different. So now we talk about sexual liberty, but in 1 century ago, 2 centuries ago, we didn't talk about that. We used other expressions. Honesty, for example. Now, very few criminal codes use the expression honesty. They use the expression, they prefer as a legally protected good to talk about sexual liberty. So this needs to be explained. And not only needs to be explained, needs to try to give reasons. Is that good? Is it better or not? To which extent this is better? What is more fair? Is better to, what is the more, I would say, what is the cultural morality behind these changes in laws, in legal codes? Okay? So these are difficult questions. I know that, and sometimes you have to deal with the history of ideas. You have to deal with sociology. You have to deal. Well, I think to be a legal historian, it's a continuous, a permanent act of humility, of modesty, recognizing that to work well as a legal historian is something that goes beyond your capacity. But anyway, we have to deal with that.
So we're coming now to the end of our allotted time. And so I want to take advantage of this to make 2 concluding remarks before we again applaud our wonderful presenters. The first remark is inspired by the screensaver for Anouar Siansi, who has been present throughout this talk. You can see a beautiful picture of liberty. And it leads me to think about one of the things that legal history and comparative law have in common. And it seems to me that what they have in common, perhaps, one of the things they have in common is their subversive nature, their revolutionary nature, that both comparative law and legal history are weapons with which we can attack and change and influence the current situation, because we see that the world could be different. And in the case of legal history, we see that the world was different, even in the polity where we are claiming to currently exist. In other words, in the United States, my own nation, the most subversive and revolutionary moves have always claimed to be conservative. They always say, well, we're returning to first principles, we're looking at original meaning and so forth. So we have a very powerful tool as legal historians, and I think the most dramatic changes that I have seen have come about often through the use of legal history. And then the second reaction, and I think perhaps this is talking about von Koenig again, but as someone, Professor Muessig was mentioning that she is a young scholar, and indeed compared to me, she is a young scholar. So I can speak as someone who is getting older. And there's a sort of a continuum and I think Professor Heirbaut made a similar remark. In one's career, in the early years, indeed, very often we're talking about iotas and whether there should be an iota here or there. And then just like great artists, as they get older, their eyesight fails, they can no longer paint a delicate picture and they start using these very big strokes. Well, the same thing, I think it could be true perhaps of historians, that as you get more deeply into your career, you may no longer even be capable of the detailed and delicate work that is done by younger scholars, but you're perhaps more confident to say things that are stupid in public. And these broad remarks can have a benefit. At least I hope so, because because I often say things that are stupid in public myself. But I think it's useful to be willing to take these broad strokes. And I think perhaps, as Professor Binyami says, this is something that is provocative and useful to our students. So with those two concluding remarks on my own part, I'd like everyone who's here to join me, please, in applauding our excellent presenters. Thank you very much.
Thank you. Yeah, thanks for your company and your patience. Yeah.
And indeed, we're very fortunate to have so many people present from, and I think this is true also of our audience, not just from the United States, from other places. That very much enriches us. Well, thank you all very much.
Yeah. Bye.
Bye-bye.
All the best.
And to our presenters, those who are still there, my thought is that I will send you a bye-bye. Thank you very much.
Bye-bye, Pia. All the best.
Yeah.
To the presenters who are still there, I'll say, I'll send you an invitation to a Zoom so that perhaps we can